Welcome to Employment Law This Week. I'm George Whipple. The economic downturn that we're currently facing means some employers will need to downsize, and that can mean layoffs. Layoffs always pose risk to a company, but the current regulatory environment presents a threat that employers may not be anticipating: whistleblower retaliation suits. Epstein Becker Green's Greg Keating tells us why.
Well, the first thing companies need to realize is that whenever there are layoffs, there is risk. And you add to that the fact that the waters in this whistleblower river are rushing very quickly and are very deep right now. Retaliation claims, once again, are the number one claim in America at the EEOC, eclipsing all other claims that are filed with that agency. And if that isn't enough, we've had a raft of new federal and state legislation enhancing whistleblower protections, creating new rights and remedies. On the federal level, the most recent amendments to the Anti-Money Laundering Act have created enormous appetite for these types of claims for the plaintiffs' bar, and states like California, New York, Virginia have all stepped up their enforcement and their protection of whistleblower and retaliation claims just in the last year. There are absolutely certain industries that are exposed to particular risk. The key driver of that is industries which are highly regulated. So think healthcare, financial services, energy. These are all industries that are in the epicenter of this whistleblower activity. Not far behind in recent years is kind of an explosion that we've seen in the tech industry, especially with unicorns, especially in California, but really all over the country.
Greg and other advisors point to healthcare as the highest risk industry for retaliation claims right now. Epstein Becker Green's Melissa Jampol tells us what specific risks healthcare companies should watch for.
The things that a healthcare company needs to be on the lookout for are any potential claims of violation of federal, state, or local laws, such as wrongful termination, retaliation, and violation of civil rights. On the federal level as well, we have concerns about whether this employee is going to file an action under the False Claims Act, under a Keating proceeding. We've seen a radical increase in individuals who believe that they've been wrongfully terminated filing Keatings. To mitigate risk, employers can focus on compliance, and more compliance. They can do that in a variety of different ways. They can review their policies and procedures, which are key to help mitigating risk, to make sure that there are clear policies and procedures that give employees the tools to internally raise complaints so that they can be resolved and remediated. Additionally, take allegations seriously. What we often see is that individuals who end up filing whistleblower complaints have raised complaints within the company, but they're considered problem employees or people with very difficult personalities, and those claims are not fully investigated. Additionally, in order to mitigate risk, companies can self-remediate. This has been a huge focus of the Department of Justice, who really wants companies to self-remediate and fix their own problems before they get reported to the federal, state, and local authorities.
Thanks, Melissa and Greg, and thank you very much for watching. We'll see you next time.